Court calls case People versus Sean Jenkins.
Alexander on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jenkins. Mr. Jenkins, can you unmute your device and state your name for the record? And please remove your hat, Mr. Jenkins, while you're in court.
Okay, just a minute. I gotta go over here.
Your Honor, we are asking for an adjournment of today's probable cause conference in order to have some additional conversations with Mr. Jenkins, as well as the prosecution in this case. My understanding is that Mr. Jenkins does have a request that he would like to address with the court himself.
Really?
That's correct. Mr. Jenkins?
Probable cause conference will be adjourned October 5th, 2023. 9 a.m. What do you want to address?
Yes, hello, how you doing this morning, Ghana?
I can't hear you.
Okay. I said how you was doing. I want to address the public offender representing me. I feel like there's a conflict. Well, I know there's a conflict of interest in the public offender representing me because my wife, her cousin, works for the public defender law firm, and she just threatened me like 2 weeks ago. So I don't feel comfortable with the public offender representing me. I don't want to get into detail about everything that happened and her and what she did, but I don't think that it would be in my best interest to be with someone that she works.
So who is it you say is who do you have the problem with at the public defender's office?
I believe her name is Roberta Higgins.
Okay, and what is she to you?
She's my wife's cousin.
Oh, she's your wife's cousin.
Yes.
Okay, and so what does that have to do with your case?
Well, what we have to do with my case is because like 3 weeks ago, she called and threatened me, talking about sending some guys over.
She was gonna send some guys over.
For me, that she would be trying to cause issues or problems with me. So, I know she been working there for quite some time, and I know she know a lot of people that's in there, and I just don't feel that
she knows a lot of people that she gonna send over to you.
Would be representing me the best of my ability on the count of.
Okay, so
her,
hold on a minute.
Not liking me.
Hold on, Miss Apple. Do you know anything about this?
Your Honor, Mr. Jenkins did make it clear that he would be requesting for our office to withdraw. I contacted management regarding his request, and at this time have been informed that there is not a conflict that would affect his representation by our office, but that Mr. Jenkins was free.
And so, Ms. Apple, as of today, have you been contacted by anybody in the public defender's office to subvert, not zealously represent, or fulfill your duties as an attorney regarding his representation?
No, Your Honor, not in any way.
I didn't think so. Motion for withdrawal or motion to force the public defender to withdraw is denied. We'll see you October 5th. Bond continued.
Thank you.
Your Honor.
Court calls case of the people versus Octavia Lewis.
Nicole Hughes on behalf of the people.
Sandra White on behalf of Ms. Lewis. Your Honor, Ms. Lewis is present. She does not wish to respond under this name, but she is present. I don't know if Your Honor can see her.
So what name today does Ms. Lewis wish to respond under? Ms. Lewis and I kind of know each other.
I resent that statement made by the court. It is my natural name. I was adopted, and then I incorporated my name. I am sorry, Mr. Simpson. I do not disrespect you, and I appreciate it if you did not disrespect my name.
Okay, so here's what we'll do. All right. Before this gets too far afield, I know that this is the individual that I know to be Octavia Lewis, as we call her here. So what do you want to do in this case, Miss White?
Yes, I was appointed to this case. I had the opportunity to speak to Ms. Lewis this morning. We are asking for an adjournment so that we can get discovery.
Ms.
Without
White,
objection,
I think
without
I think that there
objection,
was some-
probable cause conference will be adjourned. Let's just do October 5th. October 5th, 2023,
I'm through.
9 a.m. Bond continued. Thank you.
Thank you.
You're disrespectful.
Court calls the cases of the people versus James Jones, 2 cases.
Maria Sinski.
Court calls case people versus Kevin Moats.
Good morning, Your Honor. Grace Broughton, appearing on behalf of the people and standing in for the attorney of record, Laura Willenberg.
First Assistant Public Defender Kalina Anderson, with on behalf of Mr. Moats, standing in for Mr. Feaster.
Oh, everybody just standing in. All right.
We're a helpful bunch, Judge.
Yeah, right. Okay.
Your
Is
Honor,
Mr. Moat here?
yes, Mr. Moat, will you state your name, please?
Kevin Moat.
Thank you, sir. All right. What are we doing?
Your Honor, there's some discovery that needs to be shared still with Mr. Moat. We would ask for an adjournment to be able to meet with him.
And Your Honor, if I may ask for a date for a good reason, because the co-defendant in this matter is set for 9/28, and I would like the cases to run at the same time.
Okay. See, that was so nice how she did that. You know, Anderson could learn something from that.
I was taking
So-
notes, Judge. That was very
Were
nice.
you? Okay, good.
I'm blushing.
September 28, 2023, 9 a.m.
Hello, hey, Judge.
Thank you.
Hey,
Pardon?
Judge. Hello.
Hello?
Hey, I never talked to a lawyer or nothing. Like, I just be appearing in court and they be postponing it.
Well, they're adjourning it. And have you called down to the public defender's office? You have their number?
I have, Your Honor. I done called a couple of times, and the whole situation is my son was took out of my custody.
Hold on. I don't want you saying anything about the case.
No, this
Okay.
not pertaining to the case. He has nothing to do with the case.
Okay. What are you trying to tell me?
My son, the judge that gave me bond, and I was supposed to stay away from the defendant in the case or whatever the matter may be. But I have an 18-month-old son, and CPS is using these dates to keep my son away from me.
Okay, hold on. You're going to have to talk with your attorney, but you've got to make sure you get in touch with them.
I've been calling them. I got witnesses.
Mr. Mo,
Yes, sir.
do me a favor. You have their number, right?
No, they never gave. I got your sister law firm number. And
Okay,
I called
well,
that. I
it's
called
probably
that,
it.
and I
Okay,
begged
Mr.
for
Mo.
discovery packs. I went to the police station where he told me to go to try to get my discovery pack. The police told me it wasn't down there. So I feel like I'm being railroaded by this person. Like I done did 11 years before. Like I'm not trying to be railroaded.
Mr.
If I
Mo.
can fire, can I
Mr.
fire this
Mo.
attorney? Yes, sir.
Mr. Moat,
Yes, sir.
if rather than talking, you'd listen to me, maybe some of the roadblocks that you're running into, we can get past them, okay?
I just missed my son. Yes, sir.
Okay, I hear you. Do you have the number for the public defender's office?
Yes, sir. I have it.
Okay, here's what I need you to do. I need you to call down there, make sure that they have your phone number and a valid email address.
They got that.
Okay, Mr. Moat, I'm done. Because you got something to say to everything I say. I'm done.
I apologize.
We'll see you on the 28th. Thank you. Mute him. He's out.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Aaron Washington.
Nimish Ganatra for the people.
Matthew Mansour, Assistant Public Defender, with and on behalf of Aaron Washington, who's appearing via Zoom.
Mr. Washington, state your name.
Aaron Washington.
Your Honor, our office just got his new active number before this hearing. I would just like to request an adjournment just to go over the report with him so we can have some sufficient time.
Are you going to go over also why cocaine showed up in the system on the 7th?
Yes, I will.
Your Honor, I was going to ask the court if you had received a copy of the community corrections report. Clearly you have.
Yes. And then I got, so on the 7th, I've got, do you have a medical marijuana card? Let's start there.
Yes.
Have you turned that into community corrections?
No. I thought I had to
Why
turn it
not?
into the court. She told me to go through you, the judge.
Okay. And then we've got cocaine showing up in your system on the 7th. Any knowledge what that's about?
Well, I'm not denying it.
I don't know what that means.
I'm not denying the dirty drop. I'll take full responsibility for it.
How often are you testing?
Every week.
Once a week?
Once a week.
Here's what I'm going to do. I'm going to adjourn the probable cause conference in this matter to October 5th, 2023 at 9. I'm going to increase the defendant's testing per week. I'm going to have you tested 2 times per week.
Okay. I feel that's fair.
Well, thank you. I try to do the best I can. But if you test positive, you know what I'm going to do and what my next step is.
I know what time it is. I know what time it is.
What time do you think it is?
Bond hearing.
Oh, yeah. Well, I'll just revoke it. We'll see if there's a hearing after that. Got it?
I got it. Crystal clear. Thank
And
you.
sign that order increasing his testing. You also need to turn in your medical marijuana card to community corrections.
Okay. Yes, sir. I'll do that actually the next time I drop.
You might want to go back in soon because I've increased your testing to 2 times per week. So you might want to check in with them real soon because you're going to be on a twice a week thing. Okay.
Okay. Thank you. I appreciate that.
Thank you. All right.
All right.
Court calls the case, People versus Deshaun Whitfield. Court recalls the case, People versus Levante Shannon. I'm looking at this bond violation report, and my concern is I don't have a report before this one. I don't think. It rained on 8/8. Yeah, because he was arraigned on 8/8. This is really the first violation report. And from August through now, well, because he didn't appear on August 17th. Well, we didn't get the report, but here's my problem with what I'm seeing here. On August 12th, after his arraignment, he gets to an 026, then misses his scheduled retest on that August 12th day. We go 2 days later. Well, on August 14th, he blows a .066. Then it slowly goes down, so he then blows a 6.7, a 3.7, 0.37. And that's on the 14th. Then don't really have any incidents, although well, no, we do. Then on the 14th, he finally got down to an 04, but that actually went up on that day. Then that's on the 14th. Then we come down to September 8th, and he's missing other tests, but his makeup tests are showing negative. But then we get to September 8th, and he blows an 021, an 020, and a 0.16. Then on the 10th, he blows an 041, and then subsequent tests for alcohol thereafter showing that. And then later on the 10th, he missed a scheduled retest, but then later on the 10th, he's blowing numbers. Now, am I to understand that all of that is from Bud Zero? Is that the defendant? Hold it. Oh, whoa. And Mr. Shannon, let me just tell you, been doing this a long time. So you might want to think before you start answering me.
Okay.
Am I to understand that all of that's from Bud Zero?
Some of it's from O'Doul's, Bud Zero. I drink Heineken Zero, but I'm on naltrexone. So even if I was drinking alcoholic beverages, it wouldn't, you know what I mean? So it would defeat the purpose. I was just drinking because I'm around people that drink.
I didn't ask you all that.
Yeah. Well, yes, it is.
And you're saying it's from O'Doul's, Bud Zero, and what else?
And what? O'Doul's, sometimes it's Heineken Zeros. I drink a ton of them. And I didn't know because when I was on the scrambler, it never appeared. It never showed dirty. It never showed dirty. It only shows dirty on this machine. This machine is super sensitive. I didn't know it. I didn't understand the technology.
Mr. Shannon?
Yes, sir. Yes, sir, Your Honor.
You blew an 06, a 0.06.
Yeah, and I looked it up on the website after I talked to my attorney, Miss Apple. I looked it up.
Okay, so Mr. Shannon,
Yeah.
I'm going to stop you right now because you already may have talked yourself into jail, but you're not helping yourself.
Okay.
At all.
Okay.
But I'm going to give you an opportunity at least to speak with your client. I'm going to adjourn this matter to our 3:00 block with the bond hearings. I might suggest to you that between now and then that you get whatever affairs you need to get in order.
Okay.
The first thing you probably ought to get in order, and you can have that conversation with Ms. Apple, is you might want to get your story in order to me. I don't, I realize people mess up. I get
Yes,
it.
sir.
But the thing I hate more than that is when people lie to me.
I understand that.
I'm just going to leave it right there. We'll see you at 3:00.
Yes, sir.
Thank you.
Your Honor, to clarify, is that in person at 3:00 or is that via Zoom?
Hang on a second. We had a kid, but we'd like him in person.
Understood. Thank you.
Thank you.
I gotta find the bus schedule. I gotta find a way to get there. I don't
right
have a way.
past. Well, we can provide transportation if you have a problem. I don't think he wants us to do that.
Huh?
Nothing.
Mr.
All
Shannon,
right.
you can call our
Thank
office.
you. We'll
Thank you.
agree. Court does call the case of the people of the state of Michigan versus Shannon, Levante Shannon.
Okay.
All right, this was originally set and I had indicated that Mr. Shannon needed to come in person, but I think there may have been some transportation issues, which he won't have until 4:30, at least we are informed. So I've allowed him to appear for the purposes of this hearing via Zoom.
I did have an opportunity to speak to Mr. Shannon after the previous court hearing and was able to get some additional information from him. He would admit today to the violation. He informed me that he was consuming 20 to 30 beers a day of the O'Douls, which contain 0.5% ABV. And so he would admit to consuming that alcohol and understands that that is a violation of his bond, which resulted in multiple positive tests at this time.
Okay, I get that. Let me just say this, because it is about a 10 to 12 can ratio of the non-alcoholic to the alcoholic beer. Problem with that whole analysis is, while he may have been consuming that amount, and I'm not going to go into great detail on this, because of the elimination rate of a human being, for him to get to that level, he would have had to consume those 10 to 12 in the time it would have taken to do one beer. Yeah, I don't think that happened. That's a lot. But I'll accept the admission to the violation. While I still don't believe what he's indicating in terms of how that happened, but I'll accept the admission to the violation. Did we set a new date on this yet? No. What I will do is well, Ms. Apple, what were the parties intending on doing with this case?
Your Honor, I was seeking an adjournment to get some documentation of treatment that Mr. Shannon completed in discussion of potential resolution or waiving this matter to circuit court.
Well, Mr. Shannon, anything you want to do before I sentence you on the violation?
No, sir. Just that if I give sentenced to some time, I would turn myself in Monday or Sunday night to the county jail.
Well, I'm going to order that the defendant, before I sentence him on the violation, the defendant, you're to surrender to the Washtenaw County Jail by 6 p.m. this evening, or a bench warrant will issue for your arrest with no bond.
Okay. Would it be okay with you if I did it Sunday night though? Because I just got one
No,
thing
sir. No, Mr. Shannon, I don't have a problem giving people some leeway.
And that's what I'm asking for. I got something really important I got to do tomorrow.
Mr. Shannon, I'm going to advise you to let the judge finish his direction.
I don't mind, and I'll just say this, Mr. Shannon. I told you that I get people that they slip up. I get that things happen. Exactly. And I'll be able to deal with people when that does. Mm-hmm. But what I don't like is when something happens and people are lying to me. I think you were lying to me when you were first here. Yeah. I think that then through your counsel, but I mean, I understand she's advocating for you. Mm-hmm. I don't think you're telling the whole truth in terms of your consumption of alcohol. You could not put 20 to 30 beers in the time it takes for one beer to get into your system because your body can't hold it. And then you're going to be eliminating that alcohol that you're putting in. It doesn't make any sense.
Mr. Simpson,
you can shake your head all you want. You're lying to me. You're shading the truth. 6 p.m. today. Do you understand me? I'm done talking to you. or a bench warrant will issue without bond. Ms. Apple, would you like me to then set this for next week or 2 weeks out?
Your Honor, if it could be set for next week, please. Thank you.
Next week, I'll set probable cause conference September 21st, 2023, 9 a.m. Thank you. Court does call the case of the people. This is your motion. You may go ahead.
Yes, Your Honor, I did submit and file a motion with to the court, and I did provide notice to the prosecutor's office back in late August. Your Honor, I filed a motion requesting withdrawal of Mr. Phillips' plea. I did initially speak with an attorney on the morning of the plea, and I was advised that the nature of the charges that Mr. Phillip was offered in terms of pleading guilty to one count of domestic violence under 769.4A, and then a reduction to attempt RNO of a police officer resisting obstructing, which reduced it down to a misdemeanor with a dismissal of the remaining charges with potential diversion on the RNO, and again, under advisement on the domestic violence charge would be okay. However, would not provide any consequences to his immigration status, because Mr. Phillip is currently a green card holder. He does have permanent residence, but he is not a full citizen of the United States. So after speaking and go further, my own independent immigration attorney profession self, I did some further research into potential possible issues that may arise given the fact that this domestic violence charge does carry a level of moral turpitude. So I did consult with an experienced immigration attorney that now I see was much more experienced than the previous attorney that I spoke with, and realized that I provided misinformation to Mr. Phillip in terms of his immigration consequences. And given the fact that this attorney that I spoke to provided a very detailed 6-page letter with case law statutes that really connect to Mr. Phillip's potential consequences, which will lead to a high level of deportation if he does plead and accept the offer that he was provided. I did advise Mr. Phillip of his consequences, as he did also was advised by the immigration attorney that he met with for at least over several hours. They went through in detail all of the factors regarding this case and his background, etc. So based on the fact that either way, I do not want my client put in a position where he would be deported, given the fact that his wife is with him, who is the complainant. They have young children. They've lived in the United States for many years. They both are working, and I don't want to break up the family or cause any distress. So I would really like to proceed with renegotiating this matter further. So with that, based on my client not knowingly, voluntarily entering into the plea, given his misinformation of his immigration consequences, I'm asking that you grant my request to withdraw his plea.
How does that relate to knowing? I mean, he knew what he was pleading to.
Correct.
I mean, nothing in what the plea was affected the voluntariness of the plea.
Yes, Your
Right?
Honor, it did affect the voluntariness of the plea, because had he been advised of the actual nature and potential consequences of his immigration status, he would not have entered into the plea, nor would I have advised him to enter into the plea.
Response from the people.
Your Honor, the people believe at the time the plea was entered that it was knowing and voluntary, as the defendant did have a chance to talk to an immigration attorney. However, we would leave this in the discretion of the court.
When I read the motion, I don't want anybody necessarily breaking privilege, but I have the representations of counsel regarding this, but I don't have any of the documentation that you're claiming causes the plea to be set aside. And what gives the court some hesitation in that regard is this was never this case wasn't about his immigration status as we were going through everything prior to the plea and anything being taken. This was about potentially mental health concerns, other things that might have been going on, but it was not certainly about that issue. It then gets before Judge Freshour for the entry of for sentencing, and then it becomes about this issue. So while the issue on the face of it might be one that the court should be concerned about, I have nothing to say that you talk about a 6-page letter. I don't have that letter. I don't have anything on the one hand that says he received certain advice the first time with the plea, and then received advice in a different direction afterwards. So where is that information?
Your Honor, just to give you a little bit of timeline, after my client took the plea, prior to the sentencing, I did submit a lengthy deviation letter to the prosecutor's office, given the fact that it flagged my current concern with his immigration consequences. So what happened then is I received a response from the prosecutor's office indicating they too would like to meet to look into a second opinion from an immigration attorney to provide further background in terms of Mr. Phillips' possible immigration consequences. I did indeed do that, and I did provide a copy to APA Kirby, also the prosecutor that oversees the entire office, and some other accompanying assistant prosecutors. And that's when I did receive a response that either we proceed with withdrawal of the plea or we proceed with this sentencing. However, this is a privileged letter that I would prefer that if it's going to be sent with you, sent to you, it stays with you. But I would have no issue in terms of recalling this case, putting it over for you to review this letter that would provide this court very learned information regarding immigration consequences when it comes to criminal matters. So I can provide.
But no, it's not. That's not the issue, Ms. White. The issue is the claim here is that at the time of the plea, he was advised of one thing. Then subsequently, he's advised of something else. I have neither before me with this motion to withdraw the plea.
Yes,
and
Your Honor.
it wasn't something, at least from the court's perspective and the court's recollection of the case, that was even at issue in the prior proceedings.
Yes, Your Honor. With regards
Before
to
me.
Yes, with regards to advice to a client, as we know, attorney-client privilege stands, and I am not going to place a record of a transcript of my conversation with Mr. Phillip, advising him of what his immigration consequences were or are. What this is this was an off-the-record conversation that I had with Mr. Phillip with an immigration attorney on the date of sentencing. And that's when, Your Honor, as you went through his constitutional rights, I do recall, we can pull the transcript, but I'm certain and confident that you did speak with Mr. Phillip on the record and asked him, is he aware of his immigration consequences regarding taking this plea? Mr. Phillip answered in the positive. Yes, he was. But however, this is not about Mr. Phillips. If this case is pursuant to Padilla v. Kentucky, is about ineffective assistance. This is my issue. I misadvised Mr. Phillip of his immigration consequences from receiving misinformation from a different attorney.
Well, that then gets to a whole other issue of potentially having, and I was trying to avoid it, but if that's how you view the issue, then I've got to have a hearing.
That's fine.
I mean, I have to have an evidentiary hearing. I mean, I'm trying to avoid it because you're telling me there's one thing that happened, there's this. You want to cloak that in attorney-client privilege. I get that, but I can't. I mean, otherwise, what ends up happening is every plea I take would be subject to being set aside on some grounds that the court can't even see. You're telling me there's a 6-page letter. Okay, that's out there. You're telling me that there's other advice previous Again, I don't have either one of them. And then when I tell you I don't have either one, you say, well, it's not on the defendant, who I guess would have used that advice. That is all of a sudden on you and that ineffective assistance of counsel, which if that's the case, then I've got a whole other issue for me to deal with. So you want me to set this for an evidentiary hearing against her? I mean, I'm not sure what you want me to do to try to get to the point where I could even begin to grant your relief.
Well, in terms of a Ginther hearing, the purpose of a Ginther hearing is to determine and find that an attorney was ineffective. I've been in practice for 23 years plus years, and I don't do this normally, but I will acknowledge that I was ineffective. And pursuant to Padilla v. Kentucky 559 U.S. 3656.
I know Padilla very well, counsel.
So I'm acknowledging I was ineffective, and he was misadvised of his immigration consequences.
But
and that would
counsel,
call for.
Can't do it that way. Because again, the problem would be that every plea that we take that somebody may not like, either the sentence or anything else, somebody would come forth and say, I'm ineffective, I didn't tell my client this, or I told them something, and I don't have a hearing to say whether or not that would have any impact.
I have no issue or problem with holding a Ginther hearing. I'm fine with that, in which Mr. Phillip would be prepared to testify also.
Well, okay. I don't have a problem setting that. But you understand that it can't be just your admission that you were ineffective.
Correct.
I mean, because somebody's going to have to back up that certain advice was given, potentially relied upon, shouldn't have been, and then there is this other evidence that was relied upon. I mean, it's going to come down to the same thing, but it doesn't matter to me how we do it per se, but that's what's going to have to end up happening. How long will it take you to prepare for a Ginther?
Couple weeks, 2 weeks.
Do we have? It's going to have to be in person because I got. I'll set the hearing, Ginther hearing for Tuesday, October 3rd. That's in person. Before me, 9 a.m.
Your Honor, is 10 o'clock? Okay.
Pardon?
Will 10 o'clock work? I have a matter in Detroit at 9 a.m.
Fine, we'll set it at 10.
Thank you, Your Honor.
Thank you, folks.
Thank you.
Thank you, Your Honor.
Thank you. Is that it for us? That is it for us today, finally. Miss Kirby, nice of you to join us.
I figured